Dr. Suresh, sir, we are live now, sir.
Welcome to module number 16. To take us through this module, we have two eminent personalities, Professor Dr. D. Raghunadharao sir, and we are going to discuss about the ethics of AI in healthcare. And to moderate the session, we have Dr. Kalyan. Over to you, Dr. Raghu sir.
Thank you, Dr. Suresh. Module 16 is on ethics of artificial intelligence in healthcare. Artificial intelligence is not a human being, but you can use artificial intelligence to guide and arrive at several clinical decisions when you care for a patient. Most of us as medical students and then as we graduated are quite familiar with at least the four pillars of medical ethics. That is autonomy, the right of a patient to choose what they want, what they wish to take, what they do not wish to take. Beneficence, that is acting in the best interest of the patient. So this is on the physician side, ensuring that the treatment actually provides a net benefit. Non-maleficence, that is never doing any harm. So do no harm. And then justice. Justice is ensuring fairness, equality, equity in the distribution of health resources and treatment. If you are a clinical research physician, of course, you will have to drill through this with every single trial you do. But yes, that is what it is. What exactly is ethics? Ethics are a standard or something which we have agreed upon, we are obliged to do. And then we are obliged to do something which is right and never do something which is wrong towards the patient. Many people confuse ethics with morals, but ethics is actually the study of morality. Morals are, of course, at an individual level. So that means your own judgment about what is right and wrong is morals, as opposed to ethics, where it at a societal level, something is assumed to be right and assumed to be wrong. So as a profession, we have a code of medical ethics, and we today, our job is to see that if we are going to use artificial intelligence in healthcare, is there anything else we need to remember or additionally add apart from what we have already been taught through the Hippocratic Oath? Please remember, ethics is not a checkbox. It is a continuous bedside decision. With this in mind, let us see with the recent edition of the DPDP Act. The DPDP Act was actually proposed in 2023. The rules were framed in 2025, and now we have very strict governance of what can be shared, what cannot be shared, what constitutes an ethical behavior and what doesn't contribute an ethical behavior under the Act using artificial intelligence. The reason why we need to know a lot about all this is because artificial intelligence depends on a large volume, in fact, mega volumes of data, and the data belongs to patients, including their own personal details, physical details of their physical location, etc., etc. And this data is in somebody else's hand, which you need to understand. So what we are going to learn today is the most important part of how do we use AI in healthcare. So let us go to my disclosures. I have nothing to disclose, but here is a very funny cartoon. Artificial intelligence can give you very convincing arguments that are factually incorrect. So the daughter is asking the father, then I suppose politicians have artificial intelligence because the arguments that they give are very convincing but are factually incorrect. Well, let's go on to why does ethics in AI matter at all? Why should anybody know about it? Why should any physician or healthcare worker know about it? So, a clinical decision is made along with artificial intelligence. This is an ethical as well as a legal responsibility. We already know that we can use an AI decision making tool to arrive at, say, a radiological diagnosis of what is the tumor in the breast, like is it benign, is it malignant. You can also have an ICU setup where there is a sepsis alert. This patient is now going to sink into multi-organ failure or into hypertension or both. Then we have drug dosing algorithms which tell you that this is the best dose to choose in lieu of because of the underlying comorbid conditions or other drugs which you are already using. Many hospitals, especially in the corporate setup, use this AI clinical decision making tools. So what we need to understand is that a wrong AI output followed without a question can injure or kill a patient. And the AI program is not responsible for the mistake. It's the clinician who made the decision, clinical decision based upon the AI program. So that person is always legally liable. So it also goes to tell you that the Indian Digital Personal Data Protection Act, or the DPDP Act as we call it, underscores that an unauthorized use of patient data is a criminal offense. You might be surprised to know that there are many instances of large amounts of state-owned data being given to or being passed on to several software and AI development companies. The best example I know of is the National Health Services data of United Kingdom, where close to the entire population of the United Kingdom's data was shared with somebody who had access to this. This is actually a criminal offense. There are many instances across both sides of the Atlantic of such data being shared for a commercial purpose, but it is beyond what was authorized. We'll see with a few examples. WHO, ICMR, CDSCO all now require ethical AI deployment before any patient can be used. Mind you, see, DPDP Act actually specifies that the servers on which the data is stored must be within the territorial domains of India. You cannot have your Indian data, even on a clinical trial which belongs to the patient, stored on an AI tool somewhere in Europe or somewhere in United States of America. It is not like your WhatsApp, it is not like your email, it is not like Google, which can use a server anywhere in the world. No, under the DP Act, the data can only be stored on an Indian server within Indian framework. So, how to approach any decision through AI then? First, ask 3 questions before acting on any AI output. So, there is an output given by an AI tool. So, ask, is it ethical? Does it respect the patient's dignity, autonomy, consent, and fairness? Remember the 4 pillars I have told you. So, you ask the same questions again: autonomy, beneficence, non-maleficence, and justice, and say, does it actually comply with what I have studied as a student or as a practitioner? Next, ask, is it legal under DPDP Act? What's the specific informed consent given for the use of this data, for the development of this program, or for the use of the AI tool? So there is a licensed AI tool, you are going to use it. Did I take a special consent from the patient to use his data to get an output? Is it humane? Would you be comfortable explaining this decision in full to the patient and the family? So These three questions are mandatory for you to ask. After you have asked these questions, so the core ethical principles of the DPDP Act are: consent is not a signature. A blanket admission consent does not cover AI data use. For each separate procedure, just like how you take for an upper GI endoscopy, for doing a colonoscopy, for doing a biopsy, for giving an anesthesia, for doing chemotherapy, anything you do, you take a separate consent. Likewise, to use the patient's data to upload onto a clinical decision making tool, you need a consent specifically, separately, purpose defined for that act. Transparency must be ensured. That means you must understand, the patient has a right to understand why you used an AI tool and what did it recommend in very simple, plain to understand language. Accuracy is not equivalent to ethical. The tool may be very accurate, highly accurate, but still it can be deeply unfair to certain groups of patients. I will show you an example for each one of them. Human dignity typically matters. No patient can be reduced to a risk score. I will show you one example. Context, value, and personhood always matter. So the key rules are: consent must be free, specific, informed. I am underlying specific once again, unconditional and unambiguous. Data used only for the purpose clearly explained to the patient, nothing else. Patient's data, patient can retain his right to withdraw a consent any time, and you need to be very sure that that withdrawal of consent is documented and is effected. That means that his own data must be erased from the database forever. Data misuse is punishable by law, not just by policy, and ICMR 2023 adds accountability and transparency for AI. And please remember, you can't penalize a patient for not allowing you to use his data for AI or for an AI-driven clinical decision. You must continue to act in the best interest of the patient. So here is a cartoon which says, artificial intelligence tells me what to think and my news channel tells me who to hate. I'm telling you, I've never been a better time before than to be an idiot. So don't turn out to be an idiot. Please don't be dependent totally on artificial intelligence. Use your own conscience, use your own native natural intelligence to make a decision. So let us come to the first of the 5 sections. Three more sections I'll add a little later. First is consent. Is the patient's permission specifically informed and freely given? The act, as I said, is free, specific, informed, unconditional, and unambiguous. Let us see a little bit through the lens of the DPDP Act. A patient is admitted to a tertiary care hospital. On the first day, a nurse hands him over a 2-page admission form and the patient signs it. 3 months later, the patient's CT scan, blood reports, and diagnosis are used to train a hospital AI model for sepsis prediction. The form had a line that read, "Data may be used for research and hospital improvement." So, is this a valid consent under the DPDP Act? Think for yourself. Data may be used for research and hospital improvement. Doesn't mean anything at all. It is very vague. No, it is not a valid consent. So it is not specific. You did not tell them that you are going to use his data to train an AI model. Research and improvement are very vague terms. It is not purpose defined. So DPDP requires the exact purpose to be stated clearly. Research is not equivalent to AI training. It is not truly informed. Patient cannot meaningfully consent to something that he was never told in plain language. And please remember, just like in real life, even before AI existed, a blanket consent form was never valid. Here also, a blanket consent is invalid. So, important, unspecified use of sensitive data which belongs to the patient is never going to be acceptable for an AI tool to be used under the DPDP Act. So, what's the right way? So that means we can't use a AI tool. No, you can use a separate consent form. Okay, standalone form. Don't bury it in plenty of paperwork. Explain in the simplest of language. Your scans may be used to help train a computer to detect sepsis earlier. You may not benefit, but other patients may benefit. Is that okay with you? Give a clear opt-out option. That means the patient has a right to say no without that no not affecting the care to be received by the patient. So you can't penalize a refusal. Document this conversation in the case sheet. Note in the medical record that the purpose of AI consent was discussed. The purpose, the patient's choice and date were recorded. And even after giving a consent, please remember that there's a right to withdraw consent at any time. Under the Act, patients can change their mind. They may withdraw their consent today. Tomorrow they may want you to, they may want to re-give the consent for something else. So it is not an on or not, off phenomena. It's all or none phenomena. It may change with time. Section 2, transparency. So can you explain what the AI did and why in words the patients can understand? This is very important. Let us see it in a scenario. A 52-year-old woman with type 2 diabetes admitted for a foot ulcer, which is pretty common. An AI system integrated into the hospital EMR. It is already integrated. The moment you type in the patient's details, generates a risk score and recommends initiating IV antibiotics and a vascular surgery consult. Two important things. It said there's a risk score allotted to the patient, an IV antibiotic to be given, and later a vascular surgery consultation to be given. So the resident doctor reviews the recommendations and agreeing with it initiates the treatment. When the patient asks why she is being treated with an IV drip, the resident says, our AI system recommended it. It is a very accurate system. Is this enough of an explanation? Is the doctor's approach ethical? Think for yourself. Put yourself in the patient's shoes and then think for it. No, it is not. It is not ethical because there was no transparency. The patient had no idea what the AI is. You are suddenly shoving it on him, saying an AI system is meaningless to most patients. It is meaningless to most doctors or healthcare professionals, so it can't be meaningful to a patient. They cannot evaluate or question the AI program which your hospital has acquired. You have not shared what's the clinical reason why you want to put the patient on an IV antibiotic. This is important. What specific findings drove this? The patient has a right to know, and a right to an explanation is violated. Both the ICMR and the DPDP Act say patients have a right to understand how their data was used and what it led to. Please remember, with the agentic AI, this information may be completely lacking. You can't fathom how the AI actually arrived at that conclusion. There is no algorithm for you to explain. Informed consent for treatment is absent. Treatment consent requires the patient to understand the reason. The AI said so does not satisfy an informed consent. So, how then is the correct way of doing it? You should have said, Mrs. Sharma, your wound infection markers are elevated, something, procalcitonin or something like that. Blood flow to your foot is compromised. You felt the dorsalis pedis artery. Based on all your reports, we feel starting an IV antibiotic now and getting a vascular specialist to review will give you the best chance of your wound to heal without any further complication. The further complication, of course, it could lead to a gangrene or it could automatically lead to a thrombosis and the thrombus migrating upwards and then causing a pulmonary embolism. So use clinical knowledge, not AI-based knowledge. Explain the findings, risk and reasoning. Don't try to explain the algorithm. They want to know about their health, not about the technology you have in your hospital. AI should support, it should never replace the explanation. It should never replace your clinical decision. You can mention that a decision support tool flagged a concern, but you must explain what it means clinically. Document your reasoning. That means write down in the file. Write why you agreed with or you overrode the AI decision. This protects you legally and ethically. Ask if they have any questions about what you explained. Transparency is always a two-way conversation. They must feel free to ask, disagree, or seek another opinion elsewhere. Let's come to the third aspect of our discussion today, accuracy. Most of you are very fond of this word accuracy. It may not be ethical. A model can be right on an average, but still very much wrong for your patient. Let us see how it can be wrong. So this is the scenario, what we call the poverty penalty. Most of us can understand this. Those who work in the government hospitals even more so than those who work in the corporate hospitals. A tertiary hospital implements an AI model to predict a 30-day readmission risk. It was trained on 3 years of hospital data. It achieves an AUC of 0.91, which is considered as excellent. The model uses the following parameters: prior hospitalization frequency, number of missed appointments, number of investigations completed, distance from the hospital. Mark each one of them. The prior hospitalizations, missed appointments, investigations completed, distance from the hospital. The model consistently predicts worse outcomes for low income patients. A low income patient can obviously not keep his appointment, not complete his investigations. He is far away from the hospital in a rural area and has a lower frequency of hospitalization. So the clinical team begins offering these patients fewer interventional procedures, reasoning that their prognosis is anyway worse. Did you understand what I said? So those patients who fall into the low income group will now be predicted by the AI model to have a poor prognosis. That means intervening in them is not worth it. This is an accurate prediction, but it is not based upon the real world evidence. Did you understand what I meant? It means it measures poverty, not biology. Nobody asked the AI model to measure poverty. Missed appointments, fewer investigations reflect a financial hardship. It is not a health risk, genuine health risk. The model has learned to penalize the poor patient. It reinforces and when actually widens, it puts a wedge into the already existing inequality. Low income patients already get less care. An AI trained model like this on data will perpetuate and justify the gap. And the purpose, DPDP purpose limits itself is limitation is violated. Data was collected for clinical care, not to create a poverty index. Nobody asked an AI tool to create an AI poverty index so that less care can be given to them. So once again, the fairness is mandatory according to the ICMR 2023 rules. AI must not worsen health inequity. It already exists. If it worsens, it is a bias against socio-economic groups in the ethical red line. So I hope you understood that a tool developed should only be restricted to the clinical decision making, not taking into account socio-economic conditions whatsoever. So studies suggest AI equal with human experts in medical diagnosis. So this is important to understand that the human experts, the diagnosis is okay, but we are still working on giving the human touch. So please try to give it a human touch. So the right way to treat is to treat the patient, not the prediction. So the prediction is there. We are not worried about it. The risk is high, but we will still offer the best care to mitigate the entire risk. Okay, this is important to understand. So recognize the bias. Check what variables the model uses. If socio-economic proxies are driving the score, be very cautious. Separate the risk from, this is like feeling the pocket before seeing the patient. Okay, separate risk from the care decision. A high readmission score means increased support and follow-up, not withholding treatment. Override when equity demands it. I hope you understand the difference between equality and equity. Equity is bringing all of them into one line. Equality is just providing them an equal opportunity. So equity overrides equality. Clinical ethics requires you to offer the same quality of care regardless of the predicted prognosis. In fact, you should offer better care if the prognosis is predicted to be poor. That's what we do. When we do a risk scoring for an acute myeloid leukemia, those with a higher risk of a relapse and a poorer prognosis are offered a transplant program. This is exactly what you should be doing. Flag the model's bias. So report back to your clinical informatics or ethics committee that this AI program is biased. It should be restrained or retired. Document your decision clearly once again in the file that you considered the AI output but made a clinical judgment to offer full care, and this protects you and your patient very well. So please understand this concept. Section 4 is about human dignity. Never reduce a patient to a number, a score, or a tag. This is very important to understand. If you go to the Cancer Institute in Adayar, there are no bed numbers. If you have 56 patients under you in the ward, you need to remember every single patient by their name. No matter how difficult it is, unless you want to write it down in a book and take it with you. So all bed numbers have been removed. So you should understand, never reduce a patient to a number, a score, or a tag. So the situation, let us see. A busy tertiary ICU has implemented an AI triaging tool. So a triaging tool is used prior to institution of a treatment. So when the ICU was full and a new critical patient has arrived, the AI generated a priority score for all the existing patients. So all the people who are occupying the beds in the ICU, it gave them a priority score indicating who is most likely to survive and benefit from continued ICU care. Remember, most likely to survive and benefit from the continued ICU care. So Mr. K, who is a 78-year-old retired teacher with a good functional baseline, is recovering rather slowly from surgery. The AI tagged him as low priority, predicting a benefit of less than 15%. The team considers sending him to a step down ward, down to a general ward to make room for the new critical patients. So this is a dilemma which exists in your mind when you are a physician, but the same dilemma is now conceptualized and created and thrown at you from an AI decision making tool. Is it ethical to use the priority score to determine who gets the ICU care? No, it is not. It is ethically dangerous without certain safeguards. Never reduce a person to a probability. We do the probability estimation every day in the ward, in the clinic, especially for critically ill patients. But we don't reduce them to a score. We don't offer them less treatment. We offer them more treatment. He has a person with a family. There is a recovery trajectory and he has a right to care. His daughter is a nurse and he's got a very strong family support and his values prioritize survival at any cost. None of this is used in the model. Okay, survival benefit is not the only metric which you should be using. Palliation, comfort, dignity in dying are also valid ICU goals that should be included in the AI triage scores. They are not measured. Typically, they are ignored. Legal risk. The clinician remains accountable if something serious happens to when the Mr. K is stepped down and deteriorates and probably dies. So the AI program is never held accountable. It's only the clinician who will face the medical legal responsibility. So the right way then, so use AI as a support. Once again, don't use it as the arbitrator. AI can flag a clinical concern, help structure a decision. It cannot determine who is worthy of ICU care, who is not worthy of ICU care. So the final decision should always be human, always be human. So the senior most clinician, along with the family, must make the ICU step down and step up decisions. This cannot be delegated to an algorithm. Consider the values, patient's family's values, and the patient's wishes. Talk to the patient and, if possible, to the family as well. What does he want? What are his goals of care? The AI doesn't know, so you need to have it. Please document your reasoning once again in the case sheet. Write AI triage score noted, clinical and family discussion held, decision made on individual assessment. You are the only person who will be protected legally from not having used the AI algorithms output but having made a clinical decision. So the ethical principle is dignity does not have survival benefit threshold. Everybody is the same. Next section, the section 5 of 5 is accountability. You cannot transfer your clinical responsibility to a machine. The law holds you accountable, not the algorithm or the person who created the algorithm. In fact, the company which created the algorithm may no longer exist. So just like how you use a machine and you are responsible if the machine malfunctions, you drive a car and you make an accident, the car manufacturer is never sued. It is you who is going to be sued even if your car's brakes fail. Do you understand? So the same way you are accountable, not the machine, even though it's an AI machine. So you cannot say AI made me do it. A 44-year-old man presents with a chest discomfort. He is 44, but still has a chest discomfort and is sent for an AI assisted ECG analysis. The AI read normal ECG, low probability of an acute coronary syndrome. Okay. The on-call resident, trusting the AI output without examining the patient, discharged him home, gave some pantoprazole, some sucralfate, and asked him to go home, take a diazepam, and sleep. 6 hours later, the patient came back in a cardiogenic shock. He was found to have an atypical MI with a non-diagnostic ECG. Okay, the AI had missed subtle posterior wall changes. In a subsequent inquiry, the resident says, I was just following what the AI told me. I followed the AI, an acceptable defense? No, it is not. So, accountability cannot be delegated to an AI program. It's not a legal or ethical difference. Both are wrong. Neither legally nor ethically they are correct. The law holds the doctor accountable under the Consumer Protection Act and the Indian Medical Council Act. The treating clinician, not the AI developer, is liable for clinical decisions. Machine, tester, treatment, it's the same. AI is a decision support tool. It is not the decision maker. This is an important concept to understand. ECG AI is trained to assist. This resident has to assess the patient. History, clinical signs. Are there any typical features? Did he vomit? Okay. Does he have an epigastric pain? These are important. The AI did not. Automation bias is a documented danger. Trusting the AI output without validating against clinical science is an automation bias. That means you believed that it is never going to be wrong. This is a form of clinical negligence. The responsibility may be shared with your AI decision making tool, clinical decision making tool, but you are the lead. You are in the lead. You are the leader. The developer, the hospital, the clinician share responsibility, but at the bedside, it is your primary duty to care for the patient. So, does the AI output match what you see here, feel, and at the bedside? If not, trust your own clinical picture. Document your reasoning. AI reported normal ECG. Clinical features are atypical chest pain are noted. Drop T ordered. Patient observed for the next 6 hours in the emergency or the casualty. Use the AI as a second opinion, not the final answer. An experienced clinician would get a second opinion when in doubt. So AI can serve that role, but it doesn't replace your own clinical judgment. Override without hesitation. Override anything which a machine gives without hesitation when the clinical picture differs from what you are seeing. If the patient looks unwell, the machine cannot read what unwellness is. The AI says low risk, act on the patient, don't act on the score. Know the limitations of AI. It struggles with posterior wall MI, left bundle branch block, pediatric ECGs. It is still struggling. So that knowledge is your clinical safety net. So understand this and use the AI in the correct way. A few more sections which are important in the real world scenario: WhatsApp, rural deployment, patient refusals. All of us love social media and love to discuss patients along with pictures in social media. Let us see whether it is right or wrong. WhatsApp and AI. I've put WhatsApp here straight away because that is the commonest social media most of you are using. A junior doctor photographs a patient's CT scan report on your personal phone, sends it on a hospital WhatsApp group to an AI chatbot to analyze it. So you had a hospital WhatsApp group to analyze this chatbot. The doctor believes this is helping the patient get faster care. So you did not know what this CT scan was all about, but you put it onto a WhatsApp group to get an AI chatbot to analyze it. No patient consent was taken. The data is now on commercial messaging platform server outside the hospital's control. And there is no proof that one of your own people can't share it with somebody else and somebody else and somebody else, so it leaves. So just like how things keep circulating over and over again from one group to the other group, this is what is happening. You did it with a good intention, but it is still a DPDP violation. There is no secure processing. The data is on a commercial server. It is not on your hospital system. The patient never agreed to have your scan leaving your hospital for an opinion by a chatbot. The purpose was clinical care, not shared on WhatsApp for an AI review. The intent may be good, but the act is still illegal. I hope you understand what is meant by that. Okay? So, what is the then what shall we do about this? How to take an opinion? Use secure hospital systems only. That means the AI tools must be accessed through the hospital's IP infrastructure, your own hospital's IT infrastructure, not on personal phone or commercial apps. De-identify the data if you are sharing it for a clinical opinion. Remove any patient identification data like name, date of birth, MRD number before sharing any image externally. This is called data hygiene. Okay, take explicit permission for every use. If you want to share a patient's image with a specialist via a digital platform, go and tell the patient, okay, and take a consent. I would like to share your pictures, your scans with so and so who is not present at the hospital now to get an opinion. It is, please understand that WhatsApp is not a clinical platform. It is not compliant with the DPDP Act. It is not compliant with the HIPAA rules. So images shared on WhatsApp are backed up on commercial servers. Hospital loses its control instantaneously. You don't have any control on who owns that when it is on WhatsApp. DPDP penalty can be as high as 250 crores. Section 66 of the Act applies to organizations and clinicians who shared the data who may be personally named. Please understand this before you post any patient related data on social groups. Okay. So next section is urban AI in a rural hospital. A state government decided to deploy an AI diagnostic tool validated at AIMS New Delhi with an area under the curve of 0.93, excellent, across all district hospitals in Jharkhand and Chhattisgarh, two governments, to support an early TB and anemia detection. One is early tuberculosis, the other is anemia detection. Okay, AI was trained on urban patients with full lab access. A district hospital may not have a full hematology, no digital x-rays, will have a higher malnutrition rate, mostly tribal population with a different disease profile, completely different profile. So is it ethical to deploy an AI across rural hospitals without local validation? No, it is not. So it is poor generalizability, different population missing in very different variables. So it is ethically risky. And in fact, it can be potentially harmful. False negatives, missed tuberculosis, or false positives, unnecessary reinvestigation, unnecessary treatment. ICMR 2023 says a local validation is mandatory before deployment in a new population. That means you need to revalidate the tool which may have been developed at the country's best hospital, but that may not be useful if I go to Bhadrachalam or if I go to Adilabad. This is important for people to understand. So what's the solution? Steps before any AI is deployed in a new setting: validate locally, run the AI in a shadow mode. AI makes predictions, but decisions are made clinically for 3 months. Compare your outcomes in a double-blind fashion. Only deploy if the performance holds. Monitor outcomes continuously. Track what AI recommends versus what actually happened. High miss rates and false alarms are red flags. Talk to the person who developed it. Adjust it for local population, for the disease prevalence, malnutrition level, lab availability. All of them affect the AI performance. Recalibrate the thresholds for the local context. Partner with the local clinicians when you want to deploy an AI tool. District hospital doctors and ANMs know the population best. Their feedback must be shaped into the deployment before it is scaled up and validated and deployed into the rural setting. Halt the deployment if you detect a harm. AI can cause harm, it can misdiagnose, it can give a wrong treatment, suspend it immediately. No AI rollout should be irreversible. That should not happen that I have rolled it out, so devil may care, I will continue to use it. No, that is a very invalid argument. So let us come to this: I don't trust AI. You may have a patient who says, I don't trust AI at all. So a 68-year-old retired professor is being managed for a cardiac arrhythmia. The hospital uses an AI algorithm to guide an antiarrhythmic therapy selection. The patient clearly states, Doctor, I've read about these AI systems. I don't trust them. I want you to make my treatment decisions using your own judgment and standard guidelines. No AI for me, please. Does the patient have a right to refuse AI involvement in their care? Go back to your first principle, first pillar. It is autonomy. You remember me telling you that it is autonomy. Yes, the patient has an absolute right to refuse to be guided by an AI driven algorithm for his antiarrhythmic therapy. Please remember that this is a consent they are withdrawing, but they can consent later. Okay, please don't use the AI without the patient's consent or agreement. This is what is pretty important. So respecting the patient's refusal is equally important, even when the AI might help you or the patient. So do not argue, do not pressurize, do not make the patient feel that they are difficult patients. It may be legitimate, legally protected decision. So it is definitely legitimate and it is legally protected. And you must give them the same quality of care as any other patient, with or without the AI. AI refusal should not lead to a lesser degree of care. Document the whole discussion clearly. Patient informed about AI-assisted therapy. Patient declined. Treatment planned using standard clinical guideline and my own judgment. Leave the door open. As I told you, this is maybe a temporary phase. He may gain some confidence as it goes by. Explain what the AI does in simple terms. Offer the information without pressure and make clear that they can change their mind at any time. If a patient does not consent to a test being done, they also do not consent to AI being used in their care. It is as simple as that. So that is the golden rule for you to follow. So putting it all together, the 5 ethical commitments every clinician using AI must make are: one is consent, which is specific, purpose-driven, written consent for AI use, separate from a standard admission form. It should be transparent, explain the recommendations in a meaningful, patient understandable language, not an AI language. They deserve to be understand what the output is, not just the information. Accuracy, it need not always be ethically correct. It need not be fair. It need not be safe. Check who the models work for and for whom it fails. And please understand that it is not a score. Don't dehumanize a patient. context, values, and personhood override any algorithm. Don't assign a score and say low risk, high risk, etc. Low treatment, high treatment, no. Accountability. You cannot outsource your duty of care. You yourself are responsible for everything. Document, validate, override when needed, and own your own decision. That will always protect you from any legal proceedings. Okay? So it requires a continuous alignment of law. It is not a static way, clinical judgment, and patient trust. So once again, finally, ethics in AI is not a form, it is not a checkbox, it is not a simple guideline. It is a decision to be made at the bedside, following a conversation with your patient, understanding that this responsibility as a clinician cannot be transferred to an AI or a clinical decision making tool. I hope you have understood. I have given the what are the important things you might want to read: DPDP Act, ICMR AI guidelines, WHO AI ethics framework, British Medical Council Medical Ethics in 2026, and the Healthcare AI policy by Kaur et al. In 2025. These are the key references in case you are interested in knowing. The last two, apart from Dr. Kaur et al., are equally interesting. Di Martino et al., Explainable AI, how to explain AI in healthcare. Sethi et al., DPDP Implementation Review of 2025. So if you are a hospital administrator or if you are planning to acquire an AI tool, these are very important for you to understand. So finally, ladies and gentlemen, what's the best way to destroy before you destroy us? This is what AI is asking. So please don't allow AI to destroy you as a clinician and not take away your own moral and ethical responsibility. Thank you very much.
Thank you,
I
sir.
once
Thank you so much, sir. It's amazing, and I think I don't know. There's been so many questions and comments coming up. So once again, as this is as crisp as it can get and as clear as it is, and I am pretty sure every physician in this audience is questioning what I am doing with my WhatsApp, why every lab report is in my WhatsApp, and why I am doing all the consultation with WhatsApp calls, and is it under DPDP Act? So many questions from all the physicians and groups. So to continue this conversation, I will just have a couple of follow-up questions. Suresh, do we have time, right?
Yeah, we
We have
have
15 more minutes, sir.
Yeah.
And he finished well before time, sir. Raghu, sir, as usual, perfect.
Yes. So the first question is, when you are talking about the accountability, of course there is an accountability from the hospital, from the physician, from the clinician point. But how do we bring in through the act the accountability of these algorithms bias, and how do we bring in, because there is no requirement for pre-deployment clinical checkup, is there any law that we can bring, or at a legal standpoint, that everybody who is coming up, I have an AI tool, everybody right now is saying that I solve the AI problem, I can predict coronary disease 10 years before it happens. These are all the claims which are coming into the market. Is there any legal way in the DPDP Act or any act that this developer or this company who is, or the hospital who is giving that, we did the preclinical validation, be accountable in this case?
under the act, yes, there must be a validation for it to be deployed, and it is your responsibility as a clinician or as a hospital CEO to make sure that it was validated not in Caucasian patients in United States or in UK or in Ireland or in Japan or in China. It must be validated on Indian patients. This is very important for us to understand. So they may claim anything they want that it predicts. Okay, but it is your duty to understand that the validation part is yours, not theirs.
Perfect.
So before you can deploy the AI clinical decision making tool, you must validate under your own circumstances. So that is what is meant by what I said, a shadow program. So run a shadow trial. So you are simultaneously taking a clinical decision and you are taking a consent to train. I told you, you can take a consent to train for a sepsis prediction. So you can train it, see how well is this program predicting, and it should, wonderfully correlate with each other. Then only it should be deployable. You cannot say they have validated the tool in the United States, so I'll deploy it in Tirupati. No, that is not acceptable to you.
Yeah. So
One
the new
interesting
words.
question,
Yeah,
sir.
one.
Sorry to interrupt. Can we insure against the DPDP? Very interesting question.
Can you insure? Oh, okay. Does your insurance cover a machine failure? It doesn't. Does it your insurance cover a tablet or an injection or a procedure or a surgery failure? Yes, it does. A surgical failure may be covered. Okay, but it should have been done in good intention. So you need to prove that you use the AI tool in a good intention with the consent of the patient. Okay, this is important for you, for them to understand. Okay, so if the idea is that the intention should have been good, there was no malified intent at all. I did not want to earn some money from the patient, so I ordered the test, I did the CT scan or PET scan, or I did the surgery. As long as you can justify, then it may be covered under the Professional Indemnity Act, not the DPDP Act. Under the Professional Indemnity Act, yes, it can cover. So probably the Indemnity Act fellows will also look at the AI tools.
They have to. I think they have to. I think the newer terms are sovereign AI, ethnicity aware AI. These are coming up recently.
Today morning I read the state of Utah has taken away prescriptions for refills completely. Now an AI clinician, under inverted commas, which the company claims is going to do the refilling process. It is going to issue a prescription and it is going to do a refilling. So there is a big controversy in JAMA on whether this is legally valid and whose responsibility is it? The state. The state has said we don't require any clinician to sign a prescription any longer. The AI can issue a prescription depending upon your previous prescription. It thinks that it is valid, it is fine. They are forgetting that the clinician, when they ask the patient to come back for a renewal of prescription, they are going to re-examine the patient, not just for the efficacy, but the toxicity of the drug as well, or emergence of new problems, emergence of a new comorbid condition. So all these are very important, which the AI program cannot do. It is only signing off and giving. So there's a big controversy today morning. What is this going to lead to?
Yeah, absolutely. And coming back to the all the questions everybody is asking, is one thing. We don't have a very structured data collection in India historically, especially in an outpatient setting or in a rural setting. So if we start today, gathering the data with proper consenting in an ethical way, how long will it take to catch up to the existing models globally, and how are we going to catch up with the speed which the world is moving?
For those which have a high incidence, let us say diabetes, hypertension, heart disease, COPD, it will take not more than 6 months if about 10-15 hospitals collaborate, government hospitals collaborate, you will get 1 million patients. So 1 million patient database is equivalent to most countries in Europe. Country's population, not patient, the whole country's population. So it is important for us to understand that we can actually generate data phenomenally fast in our own setting. So if you have a rare disease also, because of the 1.4 billion population, if everybody collaborates, you will get the data quite quickly. The genomic data, the molecular biology data, the outcomes with the treatment you have given, their presentations, etc., will come out very quickly.
So the other things are, we were talking about the data centers, that it has to be in the sovereign soil of India. They did that, of course. And then most of the people are using again Google, which is in Mumbai, or every data center is here. But do you think at an policy level, before they write it, they have to create that infrastructure first? Because if you really look at the kind of data that if we start to collect, without having a cloud infrastructure within the India, how it is going to be implemented?
You're right. So the policy maker has to rightly decide that it is my job to see that, that is what Chandrababu Naidu is planning to do. He is going to have a gigawatt data center in Vishakhapatnam. That's exactly how it is going to be used for. It is on our own soil and it is gigapowered. So many people can, so many different conditions, you can use that data. So what the policy maker needs to understand, somebody with a mindset of somebody like Chandrababu Naidu Garu can understand this because he has a background of not just this one, but even of a blockchain technology. So this is important for policymakers to understand that we need to have our own databases on the sovereign soil of India.
Yeah, and to come back to my first question, I think there are so many questions on that part of it. So you gave an example of car being broke down and everything, but even there is some kind of a limitation that okay, you did not maintain it well, it broke down, okay, but a new car, it suddenly stopped in the highway, you got into accident. At least in that case, we have to hold the car company accountable because they sold you the car. The same thing with the farmer. Farmer did not do basic study, you prescribed
So
patient.
the liability is restricted to replacement, not to the damage that did to you as a person for your time, for your financial hardship, or it did to a harm to somebody else. I hope you understood. The liability of an instrument like a car or an ECG machine or a laptop is restricted to replacement of the defective machinery. Simple, straightforward answer. If your light bulb fuses after you put it into the holder, you can take back the light bulb because he has already written the date, he will replace it within the next 6 months. Please understand his liability. Your liability is not that. Your liability is life and death.
Absolutely.
Yeah. So you are liable for the life or the death of the patient.
So we have two more questions, Dr. Kalyan.
Yeah.
One I will take, one I will leave it to you.
Yeah, no, you take
Retrospective
you take both.
Okay, thank you. So one is retrospective data, sir.
Oh yes,
So
you can use
what is the ethical
retrospective data
structure
very
around that?
efficiently, especially if it is digitally stored, or you can digitize your data. Digitalization and digitization are slightly different, but if you can digitalize the data, yes, you can definitely use the data for prospective validation study. So you can use retrospective data just like how we use in any other clinical forum. We use a retrospective data. Yes, you train the model in a retrospective database, and then you prospectively deploy it and see whether it is working or not. We have developed the AI driven smart scope for cervicography after you use VIA and Willy, and we have validated. It is validated on roughly 10,000 images. It's a retrospective data which is used, and then it was shared with key clinicians who do colposcopy day in and day out to opine on those images, and it as an iterative loop the AI learnt it, and now it is able to predict, of course, in a red, amber, green, orange. It will tell you yes, everything is perfectly all right 90.9% of the time. The woman can go home, come back for the next screening. This is the way you need to use your own data. This is an Indian company from Pune, Periwinkle, which developed it. So yes, we can use our own data. Even diagnostics, we know it. We can use our own data to develop any AI prediction models.
Great, sir. I think we came to the last 45 seconds. Any closing remarks? I mean, I haven't heard such a wonderful lecture on ethics so far.
Yes,
So,
absolutely.
conclusion by Kalyan.
Absolutely, sir. It is a privilege we learned from you, and you've been our mentor. So it is always nice to listen, and it is beautifully summarized about what a clinician should not forget when he is wearing that coat and seeing the patient. And that is something it has to be reminded every single time. And coming from you, it is a huge boost for us in terms of okay, let us see what we can do following this, because sometimes we get carried away. Like example, WhatsApp. I don't want to get anything in WhatsApp anymore. This is one thing I learned from today's lecture. I don't want to get any images or remotes. Why don't you come, or you can bring the papers and then we can see.
Yes. Unless it is a secure server, you have some other
We
way.
don't have.
You have a secure server and I can access it.
Yeah.
I could access the entire radiology, the pathology, clinical biochemistry, clinical chemistry, anything I wanted in the hospital where I worked. But it is on a secure server and it is controlled by a login access and a finger or a fingerprint or a face recognition. It knows, it logs who is accessing its data and where did it go. It's on the hospital server, but still I can access this from anywhere in the world.
Yeah.
I hope you understood what I said.
Absolutely.
So as long as the opinion is given like that, it will remain within the hospital's own server and it is considered to be very safe way of doing a consultation using your electronic media. I don't call it social media. It's an electronic media where it is consultation. You can go to a corporate hospital in LB Nagar in Hyderabad. If an angiogram is done to look for a bleed versus a thrombus, all the radiologists in the hospital get a link at any time of the day, and every single neurosurgeon and neurologist, that is the neurosciences team, entirely gets the entire images, and anybody can give their opinion, but the opinion is recorded onto the hospital server. This is important to understand. This is how you should be deployed.
That's wonderful, sir.
Thank you.
I
Thank
mean,
you.
such a vast
Thank you for the
experience.
opportunity, Dr. Suresh, and thank you,
Thank you, sir.
Dr.
Thank you.
Kalyan, for your comments, and National Board of Examination Medical Sciences for the wonderful opportunity.
Thank you so much, sir.
Thank you.
Thank you.
Thank you, Dr. Kalyan sir and Dr. Suresh sir and Dr. Raghunadharao sir for this wonderful session. Thank you all of you. Thank you so much.
Bye-bye, sir.
Bye.